If your case is not dismissed or settled at the pre-hearing conference, you will receive a notice of hearing. This is generally sent to you and your employer 5 to 6 weeks before your hearing. The hearing is similar to an informal court trial, and you will need to convince the hearing officer that you have the right to be paid wages from a previous time. Preparation is important when it comes to the hearing, as you will need evidence, both documents and witnesses. Documents are a must, and witnesses are great if you have any. Evidence is crucial when it comes to convincing the hearing officer that you were telling the truth. Consider what evidence you should get, such as pay stubs or any formal documents that state the type of wage you receive, your pay, and the hours you worked. It is also important to consider where you will obtain that evidence. If you need documents that your employer is in possession of, or if a witness you want to testify for you refuses to come to court, you can request a subpoena from the Labor Commissioner. Your employer does have an obligation to provide you with documents regarding your employment, but if they are not cooperating, you have the option to request a subpoena. Additionally, it is important to make sure you have your story straight. Practice being able to explain the details of your claim and make sure to clearly and cohesively present your story. For more information and to find the subpoena request form, go to ulvjusticecenter.org and under Legal Information, click on Wage Claim and go to the subsection titled Hearing. In the hearing, it is important to know what you will have to prove in order to win. Since you are the plaintiff in a wage claim hearing, you have the burden to prove that you are owed wages. This is called the burden of proof. You have to show that it is more likely than not that you were not paid a certain amount of wages. The duty of proving your case is solely on you, as your employer does not have to prove that they do not owe you wages. In most cases, you need to prove the following: that there was an agreement of law or an agreement between you and your employer which specifies your work and the certain wage you earn. You can prove this by your own testimony, but it is always better to provide documents to strengthen your case. A good example of a document that would help prove this are pay stubs that show your rate of pay, or if you have a contract. Next, you will need to show the services rendered, or that you performed your end of the deal with your employer. This just means that you need to show that you worked the required amount of hours in order to earn the wages you claim you are owed. Again, testimony is acceptable evidence, but it is always better to use documents or witnesses to support it. Next, you need to show that you were not paid properly for the work that you proved you did. You will need to show that you were not paid correctly under an agreement with your employer or under the law that applies to the type of wage you receive. An example of this would be minimum wage in California, as it is set by the labor law of California. Examples of documents you could use to prove this are copies of canceled checks or any record of payments made in case, records showing that you were paid on a regular schedule, or records of bounced checks. The last thing only applies if you are no longer working for your employer and you are seeking waiting time penalties. If so, you will need to prove that your employer knew you were owed money when you left and failed to pay you that money. Make sure you are prepared to prove these things and that you have evidence that will support it. Understanding the structure of the hearing is important so you are not surprised by any part of it. All hearings have a similar structure but will vary depending on the claim. The hearing has a similar structure to that of a court trial. The main aspects of the hearing you should be aware of are the introductions, which consists of the opening remarks, taking of the oath, and the chance to make any final changes to the complaint. Next, the employee's case, or your case, which consists of the employee's testimony and documents presented, as well as the testimony and documents from the employee's witnesses, if any. Next is the employer's case, which consists of the employer's testimony and documents presented, as well as the testimony and documents from the employer's witnesses, if any. Next is the closing arguments from both sides and the closing remarks made by the hearing officer. For more detailed information on the hearing, go to ulvjusticecenter.org and under Legal Information, go to Wage Claim and click on Hearing.